15 years ago, the United States Supreme Court issued a very terrible decision called Bowers v. Hardwick. Bowers v. Hardwick said that gay and lesbian people are exempted from the protections of the United States Constitution. And for 15 years, governments and officials and law enforcement have been protecting people and enforcing rights of people, save and except gay and lesbian people. Well, thank goodness that is no longer the case. That burden, that hammer that has been used to keep gay and lesbian people down is no longer there. That means your future and the future of my children are going to be free of that terrible decision to go forward and do things like the Supreme Court of Massachusetts has done, like the mayor of San Francisco has done, like the mayor of Chicago is thinking of doing, and whatever else is going to come. And I'm going to talk to you tonight about that Supreme Court case and the cases that have come down the road, because a lot is going on. But I want to also begin with another preliminary statement. It is very important for you to understand that what I'm going to talk to you about is real. Okay? This is real life. These things that I'm going to talk to you about affect real people and have affected real people. We're not in a class examining esoteric issues. What we're going to talk about tonight and what you're going to talk about over this weekend, I want you to really think about how this is impacting your lives and the lives of other people, and please go beyond California. Many of you are going to graduate from this wonderful school and go to many other places beyond California. And although California has some special laws that we don't have in Texas and they don't have in Florida, my goodness, we are all connected, not only within the United States, but around the world. And hopefully I'll talk about some international issues as well. But these things are real, and you have an opportunity like no other generation has had to do something about it. But let's go back a moment, because the history of the gay and lesbian movement is very important in order to appreciate where we are now and where we're going. In Texas and in 13 other states, there were laws that regulated the private sexual conduct of adults in their homes. Many of these laws applied to everybody. In fact, in 11 states, and I believe Puerto Rico, they regulated the sexual conduct of even heterosexual people and people that were married. It's funny when I use that term now, because when I've used it up until very recently, when I said married, you all knew I just meant heterosexual people. But now we know it applies to everybody, or hopefully. In 4 states, like Texas, including Texas, we had a unique law that only applied to people when they engaged in behavior with someone of the same sex. I want to also encourage you as students to remember what I'm about to say next, and that is, do not believe what everyone tells you as being true and accurate, including your teachers, including lawyers, including me, including your parents, including the President of the United States. What you need to do is listen to what someone says and then go find out the true answers yourselves. Remember, just because we have laws on the books, don't make them constitutional, don't make them correct. You might get in trouble if you violate them, but that's a different thing. But be an independent thinker. That's what college is all about. Yes, give the teacher back the answer that he or she needs in order to make a good grade, but don't just take things in as the end of the discussion. If we did that, then we would still have Bowers v. Hardwick on the books, and we would still have no legalized marriage anywhere in this country, and we would still be in the Stone Ages. So be an independent thinker. In Texas, and the reason I say that is we have a Supreme Court justice, Justice Scalia, and other people who say things that are not correct. People would say things saying that the law in Texas goes back over 100 years. Well, when you really look at this, you see that that is not true. In 1860, Texas adopted its first law, but it regulated anal sex that applied to everybody. That law changed in 1943, and that made oral sex illegal for everybody. That's the way the law remained until 1973. In 1973, the Texas legislature said or decided that people who engage in heterosexual sex have matured sufficiently to take on the responsibility of oral and anal sex, but we want to send a message regarding gay and lesbian people who have sex with people of the same sex. We do not feel they are ready for the liberty to have that type of sexual behavior, and we want to send a moral message. And we as a legislature have a right to send a moral message that we do not want to encourage this behavior. And that was 1973. The next significant event was 1986. And in 1986, the United States Supreme Court, on the premise that they didn't know any homosexuals, ruled on a Georgia statute saying that the United States Constitution does not protect homosexual sodomy. Now, keep in mind that the Georgia statute was not like the Texas statute that just applied to homosexual behavior. It applied to everybody. But the Supreme Court focused on homosexual conduct. And in 1986, the Supreme Court gave the homosexual exception to the Constitution and said gay and lesbian people are not included in the protections of the Constitution, primarily privacy. That decision has been used over and over again to hammer and discriminate against gay and lesbian people, and not only against gay and lesbian people, but against anybody that a state wanted to regulate and send a moral message to. In Texas, we had a police officer who was up for a promotion. That police officer was denied a promotion, not based on anything that the police officer did in his job, but because he had had an affair with another police officer's wife, and the chief of police did not want to allow an adulterer to get a promotion. And he says, since you committed adultery, we, a government entity, do not want to condone that, so you're not getting the promotion. The Texas Supreme Court, based upon Bowers v. Hardwick, said, we do not think adultery, if homosexual behavior is not protected by the Constitution, then adultery is not protected by the Constitution, and therefore the police department had a right to make a moral decision on its promotion status. That is just one example of how heterosexuals were affected by Bowers v. Hardwick. The biggest example as to how Bowers v. Hardwick was used against gay and lesbian people was in the family law context. While this case was going on, I had many, many parents who were going through divorces say to me that when they were fighting for custody of their children, they were humiliated and embarrassed by the questioning of opposing counsel, and the fact that their sexuality, and not only their sexuality, the specifics of their sexuality. How many times did you engage in oral sex? How many times did you engage in anal sex? And why was that relevant? The reason it was relevant is we had a criminal statute that said it was a crime. And here we had people who were voluntarily engaging in criminal behavior. And as a result, they were required to have supervised visitation. They were denied possessory custody of their children. And they were denied various rights in the family law context because they were labeled criminals. There are many other examples where, because of these laws, gay and lesbian people were held back and branded as criminals. An interesting thing happened next, and that is that states started declaring unconstitutional their own state statutes under their state constitutions. Now, this movement was helpful for the ultimate case that we were going to bring. The next event occurred in 1996. In 1996, the voters of Colorado voted to amend the Colorado Constitution to say that any city or county that had a law protecting gay and lesbian people was void. And we are going to have a blanket policy over the state that says that gay and lesbian people cannot get extra or special protection based upon sexual orientation. And that was a decision of the voters to amend their constitution. At this point, it's important for us to discuss how wonderful our country is and how unique our country is. And one of the reasons is because we have a three-prong system of government. We have a legislative branch that makes laws, we have an executive branch, and we have a judicial branch. That system is a system of checks and balances. We do not simply allow legislatures to pass laws carte blanche, whatever they want to say. If we did that, do you know how many laws would still be on the books holding women back, holding African American people back, holding or allowing child labor laws to be there? We have a system of a judicial review of our laws. That's why I say, just because something's a law doesn't mean it's correct or right. We have to have a litmus test of the Constitution. And that is what happened in Colorado. And that is what is happening right now. What is President Bush saying about marriage? He is saying, let the people decide. Let the people decide. Whatever the people want is what we should have. Well, I find that ironic that a president who is holding his position because of a Supreme Court decision, not the vote of the people, should be accusing judges who are doing their jobs of being activist judges. He has his job because of the judges. And he certainly should understand how our system of government works. And those comments about let the people decide are simply political rhetoric that is fueling the ultra-conservatives to chant these things and fails to recognize how our system of government works. Well, thank goodness we have a Supreme Court that knows how our system of government works. And in 1996, we got the first really landmark decision that Lambda Legal was the lead counsel at. And the Supreme Court said that Amendment 2 classifies homosexuals not to further a proper legislative end, but to make them unequal to everyone else. This the Colorado cannot do. A state cannot so demean a class of persons, cannot so deem a class of persons a stranger to its laws. Amendment 2 violates the Equal Protection Clause. That decision is very important to what happened next. Lambda Legal is a national organization. They have a regional office in Los Angeles, in Chicago, in Dallas. Lambda Legal is a national gay and lesbian organization that fights for GLBT rights as well as the rights of people with HIV. And there are other organizations. There's an organization in Boston, and there's other wonderful organizations. Those organizations knew that in order to proceed forward, they had to get Bowers v. Hardwick reversed, and they had to get these terrible sodomy laws off the books. And the way they did it was bringing what was called, or what is called, declaratory judgment actions. And they would file an action like in Arkansas, and they would say, gay and lesbian people would come forward and they would say, we could be arrested by these laws, we could be discriminated against because there are these sodomy laws, and as a result of that possibility, we want the court to declare the statute unconstitutional. And sometimes they were successful and sometimes they weren't. But in September of 1998, something very unusual happened. And that is, John Lawrence and Tyrone Gardner were in the apartment of John Lawrence in Houston. And there was a third person who was there. His name was Robert. And Robert wanted Tyrone to come home with him, and Tyrone wanted to stay with John. And Robert was upset. So Robert left and went to the corner and called the police and said, there's a man with a gun who's going crazy in the apartment at 1226 Elm Street. So the police arrived at John's apartment. They entered the apartment, and according to the police, they observed John and Tyrone engaged in anal intercourse. Well, the police officers, knowing that anal intercourse is a crime in Texas when performed by two people of the same sex, arrested them. Now, this law is the lowest of criminal offenses, a Class C misdemeanor, punishable by no more than a $500 fine. But in Texas, Class C misdemeanors, if you are found violating a Class C misdemeanor, the police officer has the discretion of whether to actually arrest you or just write a ticket and you have to go to JP court, Justice Court. Well, for whatever reason, the police officers decided that this was so terrible that they would arrest John and Tyrone in the middle of the night at 11:30. So they handcuffed them, dragged them down the stairs. They allowed Tyrone to put his pants on. John was taken only in his underwear, thrown in the police car, and taken downtown and booked, where they spent 24 hours in jail and were released the next night after midnight. Had the police not done that, none of this would have probably happened, because John and Tyrone decided to contact a lawyer because of the way they were arrested. Not that they were given a little ticket, but that they were arrested, they were handled the way that they were handled, and they were mad and they didn't want this happening to anybody else. So after contacting a few people who recommended that they call me, they called me, and we met in my office. And quite frankly, you know, as a lawyer, we hear lots of crazy things, lots of things that aren't true. And so, you know, I'd been practicing law for 15 years. I had never heard of anybody getting arrested for homosexual conduct. So quite frankly, I didn't believe it. And so they faxed me. I thought, you know, there had to be drugs or alcohol or resisting arrest or prostitution, or maybe they were out on the balcony or whatever. But I saw the paperwork and I spoke to them, and I quickly realized that there was nothing else. There were no other charges. The sole charge was homosexual conduct. And I thought, hey, we may have something here. So I contacted my friends at Lambda Legal in New York, and by the end of the day that I called them, they had agreed to be the lead counsel on the case, and I would be the local cooperating attorney in Houston. They're in New York, and I'm in Houston, and I would assist the clients and assist with local court hearings and local procedures and assist them in doing their job, because they are the constitutional law experts that have been fighting these laws all over the country. And I'm an employment lawyer, a real estate lawyer, and so my friends asked me, well, Mitchell, how did you get involved in this case? And I said, well, I'm a real estate lawyer, and they were arrested in their apartment, so it's a real estate case. So anyways, we started this case, and we went to the first court hearing, which was by the way, let me mention, the person, Robert, who made the false police report, he got 30 days in jail. I guess the Texas legislature believes that's a more serious crime than this homosexual conduct, because he spent 30 days in jail. Anyways, we went to the Justice Court. Now, what is the lowest level court here that you have for traffic tickets or not wearing your safety belt? What is that called here? Superior Court? Oh. Okay. superior court here. I guess our justice court would be your superior court. It is the lowest level court. In Texas, you don't even need to be a lawyer to be the judge of such a court. They are really for the community type disputes. That's where this case started. And so John and Tyrone and myself and a Lambda legal lawyer, Suzanne Goldberg, we all went to justice court. Now, you might ask, as many students do, why didn't you fight the law? Why didn't you try to get your clients found not guilty and get them free? Well, that's not what we were setting out to do, and that's not what John and Tyrone wanted to do. If you remember, they wanted to make sure this law was not used against anyone in a similar fashion. So they had to plead not guilty. They had to plead no contest, which is guilty. And they were found guilty, and they were fined $150. We then appealed it to the next level, which is the county criminal court in Texas. We went there, we filed our appropriate motions, we pled no contest, and they were found guilty of homosexual conduct. Their fine was increased. And then, I was getting my clients together, we were going outside, we were going to do a press conference, and all of a sudden something happened. And this is the first of 3 times that I got chills down my back in this case. The first one is that the bailiff stopped John and Tyrone and took them over to the fingerprinting area and fingerprinted them. And that's when I realized that this really isn't fun and games. This is real, and they're being convicted of homosexual conduct. Little did I know that that conviction would also classify them as sex offenders. And so if they moved to a city where they had sex offenders, they'd have to register. They'd have their pictures posted on the sex offender websites. They'd be barred from certain jobs, and they would be sex offenders. Anyways, we then went out and did the press conference. And really, this case has generated so much attention and publicity to GLBT issues that I've said from the beginning. Lambda Legal didn't like it when I would say this, but I would say, and I want you to understand this, because the same thing is happening with the marriage debate. And that is, win or lose, we win. And the reason that we win is because the public debate and the coming out of the shadows and the education process that is being done in the straight community and the entire community advances our cause from a sociological perspective, from a cultural perspective, from a religious perspective. If we stayed under that umbrella of Bowers v. Hardwick, people would still be saying, I don't know any homosexuals. As opposed to my partner and I and our 2 babies going on television and saying, here we are, this is what a gay family looks like. These are our children, and we're proud of them, and they're proud of us. Rosie O'Donnell doing that, you doing that. Not being afraid, not letting fear make your decisions for you, but living in a non-fear environment. So, John and Tyrone were found guilty at the county court level. We went out and did a press conference, and I got calls from around the world. Germany, Italy, France, England, let alone Los Angeles and San Diego and Miami. One reason was people couldn't believe that we really had these laws, but there were 13 states that had these laws. It's not like Texas is the only state. There were 13 states that had these laws, and although they were not enforced very often, they were used to say that gay and lesbian people are less citizens than straight people, and they were used whenever people wanted to whip it out and say, you're a criminal because the legislature says so, and therefore we can deny you blank. That is how this law was used. But we got a break. We got some aggressive police officers who said, it's a law and I'm going to enforce it. So we went forward with the case. We then appealed to the 14th Court of Appeals in Houston, and something surprising happened. We won. Okay. We won. At the 14th Court of Appeals, a 3-judge panel ruled that the law was unconstitutional based upon the Texas Equal Rights Amendment. That was wonderful. We won, but I started getting calls from lawyers in Dallas that said, "Congratulations, Mitchell, but this law only covers the 14 counties that surround Houston. It doesn't cover Dallas and anywhere else. This doesn't help us." And I said, "I'm sorry, we won. We can't do anything about it. We won." Well, that's not the end of the story. Because as occurred here in California, if you recall, when you were having your governor's recall, you had a 3-judge panel that ruled that the election needed to be delayed until October, I think. And then what happened after that? The Court of Appeals decided in an en banc review, that means all the judges say, "Excuse me, this is so important, we're not going to leave it to 3 judges. We want all the judges to rule on this." Now in Texas, what happened before that decision was made is something very interesting. The Texas State Republican Party held a convention where they asked for the judges, the 3 judges. Remember, we have all Republican judges in Houston. All our appellate judges are all Republican. And the Republican Party issued a proclamation that these judges needed to be ousted from office, and other messages were sent to them unless they reversed their decision. And it was after this Republican convention was held that the en banc court, all of the Republican judges, decided this is too important. We all want to have a say in this. And I want to also report to you something. In Texas, all of our judges are elected, and all of our judges throughout the entire judicial system in Texas are Republican, except one JP judge who happens to be a friend of mine. But I had my gay friends coming up to me and saying, "Mitchell, what are you doing? They're all Republican judges. You're going to make another bad decision like Bowers v. Hardwick. The Supreme Court is a conservative court right now. Don't do this." But we felt that this was the time and this was the best case possible, and we would go forward and do the best we could. And we had clients that understood that win or lose, we win because we are doing what's right and we're engaging in a public debate. So we decided to go forward. Well, as history has it, the full court of 9 judges decided, no, that panel, just like in California, that panel was wrong. The majority ruled that the law was constitutional, the conviction is upheld, and it was 7-2, and the case continued. The next court was the highest criminal court in Texas, called the Texas Court of Criminal Appeals, and they dismissed the case saying, we don't even want to consider it. Well, ladies and gentlemen, that is where most cases end, because the United States Supreme Court is a court of discretionary review, and they only hear cases that they want to hear. And I will tell you that there are many important cases that for whatever reason the United States Supreme Court says this is not the time to hear them. Death penalty cases, lots of other important cases. So we had to tell our clients that the chance of the Supreme Court hearing this case, which would require them to probably look at Bowers v. Hardwick, was less than 3%, and probably they wouldn't do it, and this is probably where it's going to end. So we filed our application, which is called a writ of certiorari, to the Supreme Court. And do you know what the state of Texas did? They filed a waiver. They said, we're not even going to respond. Who can tell me why the state of Texas did that? Come on, one of you students, why did the district attorney's office not even file a response? How about you over there? Yes, you. What do you think? Yeah. Said they didn't want to what? They didn't want to go to the court. You are right. And the best way for it not to go to the Supreme Court is to do nothing. Because it says this case is so minor, we're not even going to waste our energy on responding to it. Well, the next thing that happened is the United States Supreme Court ordered the state of Texas to reply. And we thought, aha, we've gotten somebody's attention in Washington. Well, it was at that time that I decided I better get licensed in the United States Supreme Court. Because I was not. Because I never thought I was going to the Supreme Court. I had never been to the Supreme Court. I had never even visited I didn't even know what building it was in. So I sent in $100 with my application and I got licensed in the United States Supreme Court. Shortly thereafter, after they filed their response, the United States Supreme Court, on the same week that the adoption of my children in a foreign country, we adopted the children from a Latin American country, it was granted in that country, we got the word that the Supreme Court had decided to hear our case. Now understand, there are 9 justices at the Supreme Court. It takes 5 justices to win, but it only takes 4 justices to get to go there. So we needed 5 judges to agree with us to win. Otherwise we would go and we would lose and we'd get a bad decision. It's important to note that while all of this was going on, one of the states that reversed its own sodomy law was Georgia. So Georgia, which is the state that the Bowers v. Hardwick decision was based upon, decided under its own constitution that the statute was unconstitutional. Oral arguments were held on March 26. I went to the Supreme Court. I did not make the oral arguments. The oral arguments were made by a very experienced gay attorney named Paul Smith, who had made 7 other arguments before the Supreme Court. So he was an experienced gay attorney his job is to argue cases before the Supreme Court. He's a great guy. He did a great job. And when you argue a case before the Supreme Court, you get a special pen. It's a feathered pen, like in the old days. And he sat down at the counsel table, and I was sitting right behind him, and he turned around and he handed me the pen. And it was like, okay, am I supposed to do something with this pen? Or I give it to somebody? But he was giving it to me, and I have that pen back at my office. I guess he has a whole lot of these pens, I'm not sure, but it was a very nice gesture. But oral arguments were really good. And I want you to know that the Supreme Court justices are just regular people. Oral arguments are 1 hour. Both sides get 30 minutes. And the justices just ask lots of questions. And they express their point of view. And the audience responded with laughter, with astonishment at the different things that went on. For example, Justice Scalia and Justice Rehnquist said things like, well, do we want to get rid of this law? If we do, then gay and lesbian people can be kindergarten teachers. And do we really want gay people to be kindergarten teachers? And us sitting in the audience did what? What did we do? Let me hear it. Oh my God, 2003, a Supreme Court justice is talking like that? And other justices would say things like, well, can't gay and lesbian people adopt children in Texas? And another justice said, well, of course, there are lots of gay and lesbian people that adopt children. We thought, good. We get a little indication of what might be coming down the road. Then we have another justice who was talking to the state of Texas and wanted to know, is there really another reason except for moral disapproval of homosexuals that the state wants this law? And he said, he was getting upset. He said, I want you to give me a straight answer. What is the reason here? And we all laughed, just like you did. And he didn't understand why we were laughing. And Justice Thomas literally leaned over and was explaining to him what the joke was. Really. It was very interesting. Anyways, we thought oral arguments went good. Then we had to wait. We had to wait for the decision. And during that time that we were waiting, people like Republican Senator Rick Santorum and other people would say things like, oh my goodness, they certainly can't win, because if they were to win, that would be the end of our family structure, the end of our society. The sky would fall if they won. They're not going to win, and they can't win. Those same arguments is what we are now hearing about gay and lesbian marriage. And ladies and gentlemen, when we won Lawrence v. Texas, the sky did not fall. Our society did not end. We are proceeding forward in a very orderly manner. And the same thing is going to happen when gay and lesbian marriages are finally and officially sanctioned by the United States Supreme Court. The sky is not going to fall, and we will all go forward and live happily ever after. You heard it here first. Well, we were all waiting for this decision, and we had to be prepared for a loss, because the Bowers v. Hardwick lawyers thought they were going to win, and they lost big. So on the last day that the decision could come out, there were 39 protests/rallies that were planned across this country. There were probably one here in San Diego. But we didn't know if it was going to be a protest or a rally, because we didn't know if we were going to win or lose. So we had to be ready to go both ways. Really. And so I'm sitting at my desk at my office at 9 o'clock, waiting for the phone to ring, and around my desk are TV cameras and newspaper reporters, everybody wanting to capture that initial reaction, whatever it would be. And at 9 o'clock, I call up to New York, and I call Lambda, and I say, well, did we win or did we lose? And they said, Mitchell, don't worry. Someone will call you. You can call the clients. We'll let you know. So at 12 minutes after 9, my telephone rings. The cameras are rolling. The lights are going, just like here. I turn around, and it's my retired mother from Fort Lauderdale. I swear to God, she says, son, you won. I just saw it on MSNBC. You won. I said, I was afraid my mother heard something wrong. I didn't want to have I said, thank you, Mom. I'll call you later. So I hung up, and then we started getting the official reports. And we did get the report that we won. And not only did we win, we got a report that it was 6-3, not a 5-4 decision. We couldn't believe it. And then we heard that Bowers v. Hardwick had been overturned, with language not just overturning it today, but expressly saying, it was wrong when it was decided, and it is wrong today, and it is hereby overruled. For the Supreme Court to admit that not that things had changed and now it's wrong, but it was wrong when it was decided in 1986. And not only that, this opinion went on and on. And I'm going to read you a couple of things. Are we okay on time? We went on and on. And the Supreme Court made it clear that homosexuals were finally included as part of the United States. This, as a general rule, should counsel against attempts by the state or a court to define the meaning of the relationship or to set its boundaries. Absent injury to a person or abuse of an institution, the law protects. It suffices for us to acknowledge that adults may choose to enter upon this relationship in the confines of their homes and their own private lives and still retain their dignity as free persons. When sexuality finds overt expression in intimate conduct with another person, the conduct can be but one element in a personal bond that is more enduring. The liberty protected by the Constitution allows homosexual persons the right to make this choice. One of the most significant sentences of the decision comes at the end. And as university students, they were speaking to you as well as my children. It says, and I quote, "As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom." What a sentence. And as a result of this decision, there were no protests held. There were rallies held from coast to coast. John Lawrence and Tyrone and I appeared in Houston at a rally of 300 people in Houston. There were rallies across this country. But in my opinion, the most significant rally occurred in San Francisco. Were any of you at that rally? Raise your hand if you were. No. Well, let me tell you what happened. You were all studying hard, I'm sure. What happened at that rally was the gigantic gay pride flag that flies on the flagpole at the entrance to Castro Street was brought down for the first time. And the American flag was raised. And the crowd said the Pledge of Allegiance. That demonstrates to you the meaning of this decision to all of us. 2 days later, I'll go back to what happened the next day in a minute, but the 2 days later, with the very good timing that the Supreme Court had, was the gay pride parades in many cities, including Houston, in this country. They just timed it perfectly. That banner is what was carried in front of the convertible that John and Tyrone and I rode in Houston for the thousands and thousands of straight and gay and bisexual and transgendered and intersex people who came out to cheer us on. And I can't tell you, they put us in the front of the parade and everybody was screaming. I hear in New York, Seattle, all of the gay pride parades were just fantastic. This year, June 26, which was the decision day, will be the Saturday of most of these gay pride celebrations, will this year fall on the anniversary of this Supreme Court decision. So I'm hoping you all turn out and have a lot of fun. Let me go on with what happened. When you have a Supreme Court decision, although ones like this, that they go on, and one of the very important things of this decision that I haven't mentioned is that they go back to the Bowers decision, and they say that in Bowers, you see, the Supreme Court in Bowers made its decision, based upon the history of gay and lesbian people being classified as criminals that went back centuries and centuries, and they even talk about the homosexuality was people were put to death and this and that and this and that. Well, in the Lawrence decision, based upon the accurate historical amicus briefs that were filed, the Supreme Court put in Lawrence a retraction of those terrible historical facts that were not true. And they say that they are questionable at best. That is important for our historical perspective. But we have this decision, which is right here. You all can get these decisions and oral arguments. It's all online. You go to Lambda Legal or the Supreme Court website. You can get this, and I would encourage you to do it because the wording is very important for you to read. To me, it's very clear. And the day after the decision, something else happened that helps us understand the significance of this opinion. In Kansas, there was a case of a young man named Matthew Lyman Lamone. He had a consensual oral sex experience with an underage person. I think the party was 14 and he was 17 or 18, and they had oral sex. And in Kansas, they have a law that applies to people who have sex with people who are underage. Okay? They have another law that applies to people who have underage sex with people of the same sex. So they have two different laws. depending on the sex of the person that they have sex with. And Matthew Lamone, because he was found guilty and was sentenced under this other law that applies when you have underage sex with someone of the same sex, received a prison sentence that he is currently serving of 17 years. Had he been charged with the other law, he would have gotten a year or a year and a half in prison. Okay? The day after this decision, the Supreme Court, that was also considering that case, vacated the decision and said it's no longer effective, and sent it back to Kansas for reevaluation based upon the Lawrence decision. In my opinion, saying you can't have these unequal laws based on the sex of the person it is. You can have criminal laws, but they have to apply to everybody equally. So that was something that was very important. At the same time, in Florida, where they have a law that makes gay and lesbian adoption of children illegal, the court was pending in the 11th Circuit. All of the lawyers filed additional briefs based upon this historic decision. And they said, Lawrence changes the landscape for gay and lesbian people. One of the most important things is Florida was arguing the basis for that law was the Bowers v. Hardwick decision and morality. The same two things that the Texas district attorney was arguing, and the Supreme Court said those aren't good arguments anymore. So you would think that if they're not good for Texas, they're not good for Florida. And so those two cases were pending. Meanwhile, while we were waiting to see what those two courts were going to do, the next thing that happened in our historical perspective was the Supreme Court of Massachusetts issued its decision on November 18th, 2003. Yes, you can applaud if you would like. I felt very proud about this decision because they start the decision quoting the Lawrence case, saying that our obligation is to define the liberty of all, not to mandate a moral code. And they go on to cite Lawrence. And then they go on to decide the case under the Massachusetts Constitution, but it was nice for them to remember what the Supreme Court had just done. So I thought we were off to a good start. Little did I know that what would happen in Florida and Kansas would be terrible. Because that court that convicted Matthew of 17 years in prison said, we don't think Lawrence applies, and we're going to reconvict him under the 17-year sentence, and we don't think the Lawrence case has anything to do with this case, because it's dealing with an underage person. Not only that, they set forth 3 outrageous reasons for their decision. Let me briefly tell you the 3 reasons. Number 1 is that it was rational for the state to value relationships that may culminate in marriage over relationships that may not. I want you from this moment on to be alert to this circular argument that you're going to hear in many contexts, and that is, we don't want gay and lesbian people to get married, and we don't want gay and lesbian people to have the right to blank because they're not married. And you're seeing that all over the place, is that they want to deny you some civil liberties because you're not married, yet they don't want to let you get married. That's the first argument in this case. The second one is about spreading diseases. We go back to this generalized stereotype that homosexuals and homosexual sex spread diseases, which is not true. And they don't talk about, well, if you're in a heterosexual underage experience and you give someone a disease, you suddenly will now bump up to the higher penalty. They just say, well, gay and lesbian people, that type of sex spread diseases, so that's the rationale. The third reason is more crazy, and that is that it's rational for a state to value relationships that may lead to procreation, making babies. Because if we penalize someone who makes someone pregnant, they won't be able to get a job to support the baby that they've created in this underage sexual experience. What's even more crazy, as the dissent points out, is that no matter whether it's heterosexual or homosexual, you don't make babies through oral sex, and that's why that argument has no basis in this decision. In Florida, the 11th Circuit upheld the Florida law making it illegal for gay and lesbian people to adopt children, as I have done and my partner has done. We have adopted our children together in Texas. And it is illegal for gay and lesbian people to do that in Florida. In fact, I hear my little girl screaming right now. She's a very strong young woman. And the rationale gets into this misconception and generalization that states want children to see people who are married in order to encourage them to get married. Now, here's that circular argument again. Because gay and lesbian people can't get married, they can't present good role models of what married people look like. Now, when the question comes up, because Florida allows single people to adopt children, they say, well, they have more of a chance of getting married than gay and lesbian people have. And that's their rationale for that. I predict, based upon my experience at the Supreme Court and hearing the judges talk about gay and lesbian adoption, that the next stop for this case is the Supreme Court that is going to overrule this discriminatory law, and all gay and lesbian people in this country will be permitted to adopt children as they should have a right to do. Let me briefly talk about marriage, because in our decision, Justice Scalia says that he believes this decision opens the door to gay and lesbian marriage. And so for many months, when people would ask us, does the decision mean gay and lesbian people have the right to get married? We would say, well, the Supreme Court Justice Scalia thinks so, so we're not going to disagree with him. And, you know, there is another case that the Supreme Court decided many years ago called Loving versus Virginia. And that was ruled upon a Virginia statute that said black and white people are not allowed to get married based upon morality, based upon if they are permitted to marry one another, all these terrible things will happen. And the Supreme Court said, no, that's discriminatory, and we are going to issue a judicial declaration that people can get married regardless of the race of who they are and who they're marrying. And I am hopeful that eventually the Supreme Court will issue a similar decision for gay and lesbian people. And the sky will not fall, and it'll take a little while for people to get used to it. But I guess with the conduct of what's going on now, we're kind of getting a little preview, and this is the warm-up to what's going to come later. But what I want to close with is I want to encourage you to realize something. You know, when I was young and I was a gay person, when I was young and a gay person, I had lots of fun, but there were lots of things that I was afraid of. I was afraid of my parents finding out. I was afraid of my neighbors finding out. I was afraid of someone hurting me. I was afraid of not being able to get a job. I was afraid of not being allowed to have children. I was afraid of lots of things. And I know it's something that we each have to work through individually. But I want you to think about this just for this weekend. I want you to do your best when you go to your conferences, when you participate in your conferences. I want you to leave whatever fear you carry with you that holds you back just for this weekend. Leave that fear outside and try to support one another and live in a fear-free zone. This is a safe environment. But so much of our fears are in our heads. We think everybody is looking at us. We think that everybody's going to do something if They know I'm gay, lesbian, bisexual, transgender, or intersex. And that, I tell you, is not true. It's just not true. Certainly, we all have to take reasonable precautions, particularly if we're alone, walking somewhere at night. But that's basically it. All that other stuff is in our heads. John Lawrence and Tyrone Gardner are listed with information. They've created history. I'm listed with information. If you call up Houston Information and say, I want to talk to John Lawrence, can I have his phone number and address? They'll give it to you. And if anybody was to be afraid, you would think they would be, or I would be, or somebody would be. And I want you to know that although we've been in all the newspapers, including the New York Times, there has not been one negative experience, not one negative call, not one negative person. No one's painted anything on anything any of us own. Any fear that we had was in here, and I want to give that to you. And if nobody's bothering us, they're not going to bother you. And you can now be free to go on and lead the civil rights movement for all people and our people and do great things. Because what you do will affect my children that are 18 months old. And then they're going to sit where you're sitting, and someone's going to talk to them, and I'm going to be dead, but I'm just, but can you imagine in 18 years what that speaker is going to be saying to my children based on the things that you are going to do? It's going to be amazing, and I'm very excited about that. Thank you very much for inviting me here today, and